Welcome to the Alabama Estate Planning Podcast.
Hey everyone, welcome to the first installment of the Alabama Estate Planning Podcast with attorney Harlan Mitchell. I am your host, Mike Leon. Harlan is the founder of Bama Estate Planning by Harlan D. Mitchell Legal Services. He's an Alabama native with decades of experience helping families protect their assets, avoid unnecessary conflict, and prepare for life's unpredictable moments through thoughtful estate planning, elder law, long-term care planning. Today's episode, we're going to be talking about what happens in the state of Alabama if you pass away without a will. I'm sure that's a question that a lot of people have. Harlan's here to answer it. Harlan, it's good to see you and good to meet you. And since this is the first episode together, why don't we share a little bit about your background for the audience here? What led you to focus kind of your practice on helping Alabama families plan ahead for the worst?
Well, first of all, thanks for having me, Mike. But I used to be a former law enforcement, and a lot of the things we dealt with were families having disputes over inheritance and different things. And as I became a lawyer, I primarily was a trial attorney, and these were a lot of the things that we tried were the facts that family members had disputes because things were not properly planned for. And so I just kind of involved myself into more and more ways to avoid this court fight and destruction of families by pre-planning and taking care of things before the need arose.
Yeah. It's something that a lot of people put off for, and we're going to get into some of that in a second. So let me ask you, Harlan, for somebody that's maybe never looked into this before, can you kind of explain to them what it actually means to die interstate in Alabama and how the state kind of decides who's going to get what in terms of property?
Yes, the Alabama probate courts are strictly statutory. By definition, there is no equity except in three courts in the state, but they're going to follow the statute, and you're going to wind up your children will inherit first. If there's a spouse and children, the spouse is going to get the first 50,000, and then it's going to be split between the children. If the children are not of that marriage but of previous, the wife's going to get half, and the children going to get half, and it goes down the line to siblings, grandparents, parents, and the court's going to decide who gets what and how it's divided and sold.
Yeah. You mentioned before about these family disputes. So in your years of doing this, like what tends to happen with these Alabama families when the state's distribution plan doesn't really match what the person that passed away would have wanted?
Well, the court's just going to have to follow the statutes, and the families are often upset because they didn't get to have their way. They knew their father or their mother wanted things done a certain way, but the court is governed by statute, and they have to follow the statute. So the deceased wishes are just gone.
Yeah. This is why you have to plan. You got to write this stuff down, right?
That's
So
correct.
Harlan, let me ask you then, because you mentioned a little bit about children from a first marriage, et cetera, et cetera. So how does the outcome kind of differ? Let's take people through for like married couples, blended families, single parents, families with children from previous relationships. Like, how does the outcome differ for all those different scenarios?
Well, if it's the spouse and children of that marriage, it's going to be split 50,000 to the spouse, and then she gets half of the remaining, and the children get half. If it's children from a blended family, say the father passed away and he had children from a previous marriage, but no children with the marriage of the current spouse, then she'll get half, and those blended children get half. The single parent children's going to inherit from that single parent plus their other natural biological parent.
And Harlan, what about, so if there's no will in place, because we started the episode talking about that, there's no will in place, but there are minor children involved. What happens there, and especially in terms of not only guardianship, but who's going to step in to make the decisions? What happens there?
Well, some interested party, whether it be a family member or a close friend, is going to have to petition the court to to be appointed guardian of the minor child. In Alabama, you're allowed to appoint a guardian in your will for your children or any other document attested to by two witnesses and notarized. But even then, someone needs to file with the probate court to approve it, because that would give that person priority over everyone else.
So Harlan, again, I mentioned this was the first episode. You've introduced yourself to the audience. So let's talk a little bit about your experience in doing this. Can you kind of share some examples, obviously without giving all the intimate details, but an example of a situation where there was no will and this created stress and conflict for a family, and kind of explain what made the experience so difficult for them?
One example, their mother remarried after their father passed away. After the mother passed, the new stepfather started disposing of everything, and it was a small estate. And by the time they got to court, he had practically disposed of the entire estate, and the only thing left was a house that was severely mortgaged. And the family members were upset because they lost a lot of family mementos, memories that were just tossed by the wayside. And by the time it was all resolved, they barely covered attorney's fees.
Man, it's terrible to hear. Harlan, what about in the reverse direction of a family that came to you, got everything in place, and the stress and how that alleviated the stress? Do you have some examples you can share of that?
Well, we had one that in Alabama, there's a small estate statute. If it's currently under 47,000, you can file for a small estate if you've got a will, and then have it advertised once in the newspaper, and then you've got 30 days to close it out. So we were able to file the will, get the letters of testamentary, run the publication, and in 30 days we'd close the estate.
That's great to hear. And this is why we have an attorney on to inform the public about why they need to do this stuff. So Harlan, in that vein, and as we put a bow on today's episode, for that Alabama resident right now that stumbled upon this, they're listening to this, they haven't put a will together yet. You've explained and stressed why, but what do you want them to kind of understand about the risk of leaving things to the state versus that peace of mind that they'll get from having their clear wishes documented?
It's sort of, do you want the state to decide what happens to what you've worked your entire life for? Or do you want it to go to your children or your family through a careful, thought out plan that conveys your wishes and to ensure that your wishes are followed?
Yeah. Well said. Harlan, thank you so much for the time, the insights, and introducing yourself to the audience. I appreciate it.
Thank you so much for having me.
And that's it for today's episode of the Alabama Estate Planning Podcast. If you want to learn more about Harlan's work, visit him over at bamaestateplanning.com. You're going to find all the resources there that's going to help protect your family and your assets to give you that peace of mind. Don't forget, before you go, do me a favor, hit like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.